Yes, please.
Lord, we're very grateful indeed to the court for assisting us with the link.
I
was about to
I hope it continues for the duration of the hearing, is all I can say. But please proceed.
I'm sorry, it's only available for an hour.
Well, that's very unfortunate.
Yes. Lord, I was indicating that there is no dispute between the parties as to the tests that this court should apply. It was set out in the case of Hussein and Baswami, where I think my Lord Justice Arnold gave judgment. Page 200, the relevant passage is at page 239 of the Joint Authorities Manual.
Yeah.
I read from paragraph 50. Mr. Hussein's advocate did not submit that Judge Leatham had made an error of principle or taken into account immaterial factors or failed to take into account material ones. He submitted that the sentence was outside the range of decisions reasonably open to the judge, and accepted that this test was essentially the same test as the manifestly excessive test applied by the Court of Appeal Criminal Division to criminal sentences. As the court noted in FCA against McKendrick, it is the sentence actually imposed which must be outside the range reasonably open to the judge if an appeal is to succeed. Thus, the question is whether a sentence of 12 months was manifestly excessive for the contempts found proved. Lord, there are reasonably full skeleton arguments that have been prepared in this case and are in the
which
bundle.
We have read and for which we are grateful. Thank you.
Thank you, my Lord. I give credit, if I may, to Mr. Gray, who was counsel below, who drafted our skeleton argument. May I speak to that? And the court may feel that the appropriate place to start is not, in fact, the beginning of the skeleton, but where we seek to invite the court to admit new evidence. And can I make it perfectly clear that these elements of the skeleton are not, of course, they have their individual elements, but they fit together, we submit, because for this reason. The new evidence relates to our submission that Ms. Khan was under pressure from clients, time at which she committed her contempts. Clearly, an intervention by the respondents is nothing short of a cataclysmic event for a solicitor. But a solicitor in a normal frame of mind and with a normal ability to reason and so on, should we accept to be able to bear the pressures applied by an intervention? But it is our submission that when we look at the evidence, in this case, of Ms. Khan's mental state, that it significantly, that the pressure significantly impacted her. And I will come to Dr. Chowdhury and his evidence in due course. In other words, the two issues are linked. My Lord, again, going to the test for the admission of new evidence, it's well known to this court, I'm confident. Ladd and Marshall, as interpreted in Taylor and Berezovsky in the light of the implementation of the civil procedure rules. Ladd and Marshall is in the Joint Authorities bundle, the relevant passage from the judgment of Lord Denning.
Yes, well,
page 103, which I'm sure
everybody knows that one.
Of course, and I won't trouble the court with that. As the court sees from, and I'm going to speak to the skeleton at page 10, The evidence we seek admission of is limited in form and scope. It comprises, as the court sees, two emails which are appended to Mr. Livingston, the appellant solicitor's affidavit, which appears at tab 6 of the core bundle.
Two emails, the 15th of January, one of 1402 and one of 1432.
The Arnold, yes. And Mr. Livingston explains in his affidavit the circumstances in which those emails were received by his firm. And so far as chronology is concerned, there is a chronology in the bundle which I won't take the court to, but it's there for the court's benefit if it wishes to see how everything fits together. These emails, post-dated, of course, the contempt hearing. That's the point, obviously, or it wouldn't be fresh evidence.
Well, and not just the hearing, they post-date the judgment, which is perhaps the key point in time for this purpose.
Exactly. I mean, what the emails speak of is, in our submission, clients who were, in their view, very happy with the way in which their files are being handled by Ms. Khan's firm. The court can, in our submission, reasonably take the view that these were sensitive inquest cases. The court, I think, knows that Ms. Khan specialised in this sort of work.
Well, you say that, but that's news to me. And the reason why it's news to me is because there's no such finding in the judgment. The reason why there's no such finding in the judgment is because there's no evidence from your client.
I accept that.
Before the judge.
And I make my submissions fully cognizant of the fact that she has not put evidence before the court on her behalf from her. There is no evidence. Well, even if I'm wrong to make that submission, the fact of the matter is, as the court sees, first of all, the clients were extremely happy with the way in which their cases were being conducted by Ms. Khan. They were deeply unhappy about the intervention by the SRA and the effect upon their cases and their documents of the intervention by the SRA. And the depth of their desire is clearly set out in these emails, and with their specific instructions not to share those files which they consider to be their property. And the point I made about sensitive cases is perhaps, if a court turns to page 63, which is the email of Claire Forcer, there's a paragraph halfway down the page. As Soophia's client, I have instructed her not to share my files, which are my property and not Soophia Khan's, with the SRA, who have a high population of army solicitors posing a huge conflict of interest in my case. These files are removed from the care of Soophia Khan. I will consider them stolen. And then the email goes on. If the SRA continue to pursue access to my files, which will certainly cause myself and my son and our family damage to our case, I will see no other option to sue for damages and so on. And then the further capitalised indication that they do not consent to third-party access by the SRA or any other third party of those files, and the further indication that the conduct, in their view, of the SRA has caused great distress to them as a family in already difficult times. So there was, and we would submit that the second email, although not perhaps expressed in quite as trenchant terms, equally makes it clear how distressed, upset, and the clients were with the intervention, and how content they were with their cases as they were being conducted by Ms. Khan.
Can I ask you, the evidence is that, from Mr. Livingston, is that these were unsolicited.
Yes.
Do we have any evidence as to the genesis of these emails? Because one thing is perfectly clear is that they've been based off the same draft.
Yes.
They use the same language and make the same spelling mistake.
There are elements of them, I accept, which are identical. And there are a couple...
Quite a lot of it. But my question is, do we have any evidence as to the genesis of these emails?
No.
We don't.
No.
Somebody has thought it appropriate to cause two emails in very similar terms to be written, but we have no idea as to who that might be.
No.
No. Thank you.
My submission is that they make it clear, all the points I've made already are very clear from the contents of those emails. And as I say, that there is no question but that a solicitor whose state of mind was normal, so to speak, should be able to resist this sort of feeling on the part of the client, not resist it, to assist the client by, for example, giving them advice, by assisting them to fresh representation and so on. I accept all that. But it links to my submission, which will come just in a moment, that Ms. Khan, there was good evidence before the judge. Ms. Khan's faculties were not properly engaged at the time by reason of stress and anxiety. Of course, this comes to, because we'll discuss this a little bit later, but as the court knows, there are very clear criteria which the court must consider. And I don't suggest otherwise. Mr. Justice Lee didn't consider the criteria set out in the authorities. There's no dispute between the parties about the criteria to be applied, or sorry, the criteria to be considered in assessing sentence. I hope to make it plain that we're not suggesting that the judge erred in that respect in any way. It's a different focus to our submissions in this case. And so in our submission, the position is this, that the emails, in fact, do stand the test in our submission posed by the common law authorities and under the civil procedure rules. It is our submission that they go to an important aspect of mitigation in this case. I shall, if I may, deal with that in a little bit more detail when I go through those particular points derived from the authorities about matters which the judge took into account and should have taken into account, and how he should have dealt with it. Lord, the facts are set out in the skeleton argument. There's no dispute about the facts. I'm not going to go into them unless I'm required to do so.
No, we've got those well on board, thank you.
Yes, thank you very much. And can I turn, therefore, to the next element, the submissions on behalf of the appellant, which are paragraph 16 of the skeleton argument, involving the lack of psychiatric evidence. Well, in fact, it says there's a lack of psychiatric evidence. There was, as the court knows, in fact, medical evidence before the court from a general practitioner, which I should come to in a moment. So there was some medical evidence before the court.
Yep.
But as the court sees, as the skeleton notes, contended by the appellant that before the learned judge heard the substantive application, an opportunity ought to have been given to obtain psychiatric evidence, specific psychiatric evidence.
Well, are you in a position to pursue that point? I appreciate there's the second way that the matter is put at paragraph 18, but so far as the point raised at paragraph 17 is concerned, as Mr. Allen points out in his responsive skeleton, there was an application for an adjournment on the 16th of December to adduce expert psychiatric evidence. That application was refused by the judge on the 16th of December. There is no appeal against that order. It
No, there
would
isn't.
require permission anyway, and your client would be out of time.
Yes.
The fact of the matter is there is no appeal.
Yeah. Well, if that is the position, and I can't argue with that as being the factual position in the case.
Right. So I take it, therefore, you pursue it on the second basis.
I'm sorry, my lord.
I take it, therefore, that you pursue this point on the second basis rather than the first.
Yes.
Thank you.
Can I also ask you, on the chronology, so the application from German was in December, 17th of December, and was refused. In fact, although the judge announced at that hearing that he would find Miss Khan in contempt, he didn't proceed to sentence straight away.
No, he didn't.
Sentence takes place in January. I think that was 4th of January it was handed down, is that right?
Yes.
No,
it's not.
it was
It's not.
originally
It's
scheduled for that
It was
date,
going to be
Later.
the 4th of January.
and
Well,
then it was adjourned to
Yeah.
ultimately the 12th.
Exactly.
the 12th of January. So even without the application from Germany being granted, there was time for Ms. Khan to have obtained psychiatric evidence before judgment on sentence was pronounced.
Attempts were made to seek psychiatric evidence, but it couldn't be obtained.
Do we have evidence of the attempts that were made?
No.
Thank you.
I'm anxious not to give evidence.
No, well, I'm very conscious that we should act on such evidence as was before the
Exactly.
court below, or such fresh evidence as we give permission to adduce in this court.
I follow my lord's point. The point I would make is that the court, and the point I'll come to directly, is that the fact of the matter is that the court did in fact have Dr. Chowdhury's
Yes.
letter at the time at which sentence was passed. And as the court will see from the way in which the skeleton argument is developed, it is our submission that the evidence of Dr. Chowdhury was not given the weight it deserved. The learned judge expressed himself in a particular way which is set out in the skeleton argument, expressing himself to have given full weight to the evidence of Dr. Chowdhury, but then saying it was of limited assistance effectively. And this is paragraph 18 of the skeleton argument.
Yep.
I would submit that in fact paragraph 18 of the skeleton does not in reality represent the true position, because what the drafter of the skeleton indicated was that it would be submitted that in the absence of anything to the contrary, having refused the appellant the opportunity to provide further and potentially more cogent evidence on the point, the learned judge was bound to approach the exercise of sanction on the assumption that the appellant was labouring under psychiatric condition that impacted on her reasoning such that the degree of her culpability, her appreciation of the seriousness of the breaches, and her ability to accept responsibility for the breaches was impaired to some degree. The fact of the matter is, of course, that the judge did have, in fact, Dr. Chowdhury's letter. It wasn't a case of an assumption being required. And in fact, for that purpose, can I take the court, please, to page 46 of the core bundle.
Yep.
Where the learned judge, letter J, paragraph 36, set out, in fact, the content of the letter from Dr. Chowdhury, which is as follows.
Can we look at the actual letter? I'm sorry. It must be. It's in the bundle.
No, well,
It's a tab 13, page 159.
yes. Does my lord have it?
Yes. Thank you.
It is to confirm. It is to confirm that Soophia Khan is NHS registered patient malpractice. She is suffering from work-related stress and anxiety. She's feeling very stressed due to the ongoing litigation actions by the Solicitors Regulation Authority Limited, SRA. This continues to have, and these are in my submission the very important words, this continues to have a profound effect on her mental and psychological well-being, and then these even more important words, and affecting her comprehension and understanding of recent issues in litigation matters against SRA. It goes on to speak about the injury to her left hand. She had a left hand accidental injury while lifting a heavy object a few weeks ago, requiring tendon repair surgery on the 3rd of December 2021. She will be in a hand splint for another 4 weeks and will be followed by the hand specialist for further management and physiotherapy, and recovery is expected to take approximately 3 to 4 months. She continues to have problems in concentrating on daily matters and SRA litigation matters. Due to her continuing current symptoms, she is still unlikely to be in a mental state to be in a position to fully evaluate and comprehend the issues before the court in relation to the contempt applications. She has been followed today for her mental health symptoms and been re-advised to have counselling for her symptoms. She is being referred to a private psychiatrist in view of her current mental health condition, dated, as the court sees, 16th December 2021.
Thank you.
Now, the points I'd seek to derive from this are, I hope, very obvious ones, very, very clear ones. This was the only evidence. This was the only evidence before the court in relation to her medical condition. The doctor, in expressing his opinion, did not merely indicate that she was stressed due to suffering stress and anxiety due to the ongoing litigation, but went on to set out his professional opinion as to the effect of that stress and anxiety on her ability to comprehend, the issues before the court in relation to contempt applications and to fully evaluate those applications and those issues. Now, our submission is that, as I say, that being the only evidence before the court, it was a crucial element of mitigation going to a number of different aspects, which I'll come to in just a second, of a number of different factors which the court is duty bound to consider in relation to sentence. And may I take the court, please, to that point now, which is page 4 of the skeleton argument. Paragraph 13, submitted the sentencing the appellant to a period of 6 months in custody in the terms which were set out, and the court knows those terms, the learned judge heard. In doing so, the learned judge accepted the propositions identified at paragraph 13 and 14 of the second skeleton argument as summarised in Ott Critti International Investment Management Limited and Gassemi and others, following.
Yeah, well, you needn't read
And
it
the
out.
court knows
We
those.
read it in the judgment and in the skeleton.
And I know that my lord, each of my lords has been involved in cases of this sort over a long period of time. That, so far as autocrity is concerned, the number 5, the key questions for the court are the extent of the defendant's culpability and the harm caused by the contempt. And it's the extent of the defendant's culpability to which, in my submission, Dr. Chowdhury's conclusions go. But it's much more than that, because if the court, if I can take the court to paragraph 15,
Yeah.
where the Law House case criteria are cited, my submission is this: if one looks through these criteria, whether the claimant has been prejudiced by virtue of the contempt and whether the prejudice is capable of remedy, that's a separate issue I'll deal with in just a moment. B, the extent to which the contempt law has acted under pressure, I've already dealt with that. C, whether the breach of the order was deliberate or unintentional. Now, it is arguable, and I submit, it is a feature of this case, that if the doctor was correct, and as I say, there was no other evidence to the contrary, then I'm not suggesting for a second that Miss Khan didn't know at all what she was doing, but it played a part in my submission in the breach of the order, why the order was breached. In other words, I'm not saying it provides a complete defence. I would never suggest that for a moment, but it is in my submission a point of significant mitigation. It certainly goes in my submission to the degree of culpability, and it's highly relevant to that. It certainly, in my submission, goes to little f, whether the contempt law appreciates the seriousness of the deliberate breach. It certainly, in my submission, goes to little g, whether the contempt law has cooperated. And in my submission, it certainly goes to h, whether there has been any acceptance of responsibility, apology, any remorse, or any reasonable excuse put forward. So what I submit, so far as this is concerned, is that Dr. Chowdhury's conclusions are relevant to 5 out of the 8 criteria derived from the Law House case.
Can I just pick you up on the last 2 points you made, little g and little h? I think that you'll correct me if I'm wrong, that this is not a case where the contempt law has in fact cooperated or has in fact expressed apology, remorse, or reasonable excuse. So your point is that it's an explanation of why she hasn't done those things.
Exactly.
Yes.
Yes. To say she hasn't done it is the starting point. The more important question on culpability, well, it's really part of culpability. Why has she not complied? And my submission is that, at least in part, Dr. Chowdhury's conclusions may very well provide an explanation for why it is, at least in part, that she failed to comply. And in fact...
I'm going to repeat a question I put earlier. We don't have, and the judge didn't have, any evidence as to why she hasn't complied. We have Dr. Chowdhury's report, and you're inviting us to infer that may provide an explanation, but we don't in fact have evidence either from her or from anybody else saying this is why she hasn't complied.
I accept that.
Yes, thank you.
So my point is that the inevitable inference to be derived from Dr. Chowdhury's conclusions, together with, although I suppose it's all part of the reason why these symptoms were present, together with what I've described as the cataclysmic effect of the intervention, in my submission provide a good explanation for why it is that she failed to comply or failed to perform the various acts or requirements as set out in the Law House case. It really all goes to culpability. These are just, in my submission, different aspects of culpability.
Yeah, all right.
So my submission is that, and of course, the court has the way in which the judge dealt with this. Can I just assist with that? It's derived from paragraph 18 of the skeleton argument. Although, of course, the court will see in the judgment itself how it was expressed, but he said he'd applied full weight to the sentence imposed in relation to the issue of the mental health aspect. But then went on to say, at the bottom of paragraph 18, where there is a quote, the learned judge appeared to conclude that its only effect was to go some way to explaining why she adopted such a wrong-headed attitude to the intervention and to the subsequent orders. And it seems, therefore, that the learned judge, having indicated that he would apply full weight to that in mitigation, did not do so. Even if that's thought to be over complicating the matter by reference to the precise words used by the judge, our submission is that the judge did not, in fact, give anywhere near, with great respect, sufficient weight to the medical aspect of this case in determining culpability and the issues that he had to determine in relation to the law house criteria. Now, could I also make one further point, which is this? I have, throughout the course of these submissions, indicated that it's the appellant's case that the learned judge failed to give sufficient weight to various aspects of the, or failed to give sufficient weight to various aspects of the case, failed to take into account various things in a sufficient way. One of the problems that there is in that is that the learned judge did not, in fact, indicate what his starting point was.
Do you say he was obliged to do so?
It would have been helpful, let me put it this way, it would have been very helpful had he done so, so that one could have judged the degree of discount that he gave for those features of mitigation which he found to be present. Let me give the court a parallel. In a criminal case, a judge certainly would indicate what the starting point was, and then go on to, it's part of the sentencing exercise that a judge is required to fulfil, in fact. And there are, of course, as the court knows, heavy parallels between criminal sentencing and the principles of criminal sentencing and the principles of sentencing for contempt.
There are parallels, but they're not the same exercise.
No.
In criminal cases, one's always sentencing for past offences, and there are sentencing guidelines which we're obliged to have regard to. And sentencing in criminal cases has become much more structured than it used to be.
It does.
Whereas in civil contempts, one has the feature, although one is in part punishing for past contempts, one is in part, in a case like this,
yes,
imposing sentences to secure compliance,
yes,
which forms no part of the criminal sentencing process.
No, I agree. I accept.
There isn't a sentencing guidelines council, and there aren't guidelines in the same way, and also contempts vary enormously in their factual differences.
They do, but with great respect, so do many criminal offences that fall within the same category of offending.
Sometimes. Yes. It's not worth taking up time debating.
No, I take my Lord's point. I'm not suggesting that the process is identical. There are many reasons why it's not. What I do submit, however, is that there are elements of this that are this, or that should be the same. And I do submit that it would have been extremely helpful.
Well, maybe so, but you're not submitting that there's any error of principle on the part of the judge in failing to perceived by way of a starting point and an articulated discount.
No, but it would have. I can't, because there's no formal code or structure that the judge.
There's no authority from this court saying that's how you should do it.
No. My submission is, in fact, I think it does arise, in fact, in this appeal, that there should be. Because then, in just the same way as in a criminal case, from the point of view of transparency, comprehension by those professionals on each side of the argument, the Crown and the defence, and so that a defendant may know how it is that the judge has reached that sentence, what factors have been taken into account, what discount has been given, for example, for plea. I can just touch on that, actually, if I may, just briefly later. It provides a comprehensive framework that, as I say, assists everyone in the case, and assists this court in the criminal division when it comes to appeals against sentence. But no, I'm not suggesting the judge erred in principle in failing to allocate a particular starting point. As the court knows, some judges do, and then indicate.
And the same judge may adopt a different practice in different cases, depending on the facts of those cases.
I hope I'm not trying to suggest that the judge failed in principle, as far as this is concerned.
No, you've been very clear. Thank you.
What I'm suggesting is that the absence, let me put it that way, of a starting point and specific reference to the degree to which the judge, in qualitative terms, has taken into account the various mitigating features would be helpful. And all I say is it makes my task more difficult, and it may or not, but I submit that it may make the court's task more difficult when it comes to assessing whether the judge has in fact applied proper weight to various considerations. Because, of course, what the judge did was just to go through the various factors and then to say, for all these reasons, I have come to this conclusion that she must serve this sentence and set it out, structured it in the way that it did.
Yes, but as I think you've already accepted, it's the bottom line that matters, and your submission is that 6 months is manifestly excessive.
Yes. I'd like to have been more. What I might call precise, in the sense of saying precise where the judge particularly had erred, in the sense of looking at the arithmetic of things. I know, and I appreciate, and I accept that the Court of Appeal Criminal Division have indicated that it's not a wholly, even in the criminal case where there are guidelines and so on, it's not a wholly arithmetical exercise. I accept that. But all I'm saying is it does greatly assist.
All right, so does that take us
I've said everything
to the question of admission?
Now, paragraph 21 of the skeleton argument. The judge concluded that by reason of the status of Ms. Khan as a solicitor, she should be held to a higher standard than an unqualified defendant. Now, there is, I don't think there's a precise authority for that proposition, but I'm not going to argue to the contrary. I'm not going to suggest that that is wrong. But what I do submit is that that is certainly that is appropriate where the solicitor is not labouring under the problems identified by Dr. Chowdhury, because the very fact of the inability as Dr. Chowdhury says, to be able fully to evaluate and comprehend the issues before the court. And the fact that he opined that that the anxiety and stress had a profound effect on her mental and psychological well-being are just as potent factors in my submission in the case of a solicitor as they are in the case of a layperson. And the judge took no account of that whatever. He merely said that because she was a solicitor, he held her to a higher standard. As I say, don't dispute that as a proposition to start with. But in the context of this case, given the evidence of Dr. Chowdhury, it is clear in my submission that she could not exercise the understanding of the law without, as it's put in the skeleton, without let or hindrance. Anyway, it's a point I make. I can't. It's a simple, straightforward point.
Yes, thank you.
And won't benefit from repetition. My Lord, admission, non-compliance. The chronology of matters is, as the court knows, set out. The fact of the matter is that, can I just briefly, please, take the court to the chronology?
Well, the key point is the letter from your instructing solicitors of the 9th of December, which we have at tab 12, page 155.
Well, that's the point. My Lords, we've got there before now. The point is, as soon as the new solicitors, or the solicitors were instructed, because she was unrepresented before these proceedings, the court sees that a letter was sent virtually straight away afterwards, almost immediately after a conference had been held, in which she admitted her breaches. Now, I know the respondents in this case will suggest that she did not admit contempt. Although she admitted the breaches, she didn't admit contempt. There is some force in that, but not very much in my submission, because the only issue was a legal one, really, which was to the effect of the degree of mens rea required. And there was more of a, I would submit, as is clear from the judgment, there was much more of a discussion rather than an argument about that. And the effect of the letter of the 9th was as is set out in the skeleton. Now, it is in my submission settled law that in the same way as guilty pleas in criminal case yield a discount on the ultimate sentence, so too it is with sentences in these circumstances.
But as you're fully aware, this court held in the Lacatema and Sue case that there was no absolute rule to that effect.
Yes, and the position is the definitive guidance from the sentencing council is to the effect that a maximum level of reduction is 1/3 if the plea is indicated at the first stage of proceedings, which is defined as the first point at which the court seeks an indication of plea and which is recorded by the court. I'm sorry for this, I should have put the sentencing council guidelines in the document in relation to discount for plea, but it's, this is the position.
Well, it's set out in FCA McKendry.
It is
anyway.
set out in the authorities, and it's set out in other sources too. If I can just say this, sliding scale reducing to 1/10 on the day of trial. But the force of this submission, in my submission, is that, force of this argument in my submission is that immediately the new solicitors were involved, there was an acceptance of that she had failed to abide by the court's orders.
All right, but can you assist us on this question? As my Lord has already pointed out, and as you've accepted, in this context, one of the key purposes of the jurisdiction is to attempt to secure compliance
Yes.
with the court's orders. What weight do you say the admission can have in circumstances where, as at the date of the hearing, before the judge's judgment, there had not only been zero compliance, but no statement or evidence of any future intention to comply, and no evidence has been put before this court of any compliance even now?
There are two reasons in my submission why a discount for a plea exists in our law. First is, in my submission, because it represents tangible proof of remorse. The second is, in my submission, that it saves court time in not litigating matters which are the subject of admission by the defendant, and therefore is of significant value to the administration of justice by the freeing of court time which would otherwise be spent in argument or evidence about matters which are accepted by the person pleading. So it doesn't have any bearing on the first element, but it does in my submission on the second. And for that reason, in my submission, there should have been a discount afforded the appellant for her admission. And I do come back, if I may, I know I have repeatedly come back to it, but Dr. Chowdhury's conclusion is also relevant to this in the sense that when she was unrepresented, it was immediately after she was represented by solicitor and had a conference with counsel that the letter was sent. And I've already made that submission. But I do just add on the fact that Dr. Chowdhury's, in fact, it's quite good evidence in my submission that once a third-party expert was involved, she did have a change of stance. Not a complete change, I accept, for all the reasons.
I don't quite understand that, because the chronology doesn't fit. The admission was made on the 9th of December.
Yes.
Dr. Chowdhury's evidence was produced on the 16th.
Yes, what I mean
a week later.
Yes, absolutely, but that is to assume that Ms. Khan only began to suffer in the way that Dr. Chowdhury speaks of on the 16th of December. There's no reason.
Since he expresses himself in the present tense, and since he does not tell us when the symptoms emerged, what inference can we draw?
Well, because he says that that the stress and anxiety is as a result of the litigation, which had by that stage been continuing for some time.
Indeed, the committal application had been pending for 2.5 months by that date.
Yes.
And it was the day before the hearing, which one might well regard as the date of maximum stress.
Yes.
Can I ask you something else? You quite rightly identified one of the reasons, certainly in the criminal context, why discounts are given to people who plead guilty, is it avoids the need, usually for a jury trial, of all the cost and time that's taken up in hearing a contested not guilty plea.
Yes.
In this case, the judge said, and I was struck by it, I make no discount for the admissions because they led to no saving in time or costs. how do we deal with that
Well,
assessment by the judge? And he was the one who heard the application. My understanding is that there was argument, or a debate, you say, on the 17th as to whether, notwithstanding the admission that the orders had not been complied with, which on the face of it was something that she was pretty well constrained to admit, because it would have been very difficult for her to say, no, I have complied with the orders. There was still substantive argument as to whether she was liable for contempt on the grounds of, as you say, mens rea.
But, yeah, it removed one element of the necessity for proof.
Yes, but unless she was going to say, I dispute that there's been non-compliance, this is what I say I did to comply, that would not have taken up very much time, because there was evidence before the court of the negative. We've not had the files. My problem was not so much with that, but with how do we, on appeal, deal with the judge's own assessment that these admissions didn't cause any saving in time or costs. And generally speaking, we're obliged, sitting here, to defer to the judge's own assessment of what's taken up time in his court.
Yes, I accept that. It's a difficulty I have to confront.
What do you invite us to do with
Well,
that?
to say that the learned judge was in error so far as that's concerned, because the admission of that she had breached the orders took out of the equation, as it were, as far as the evidence is concerned, and any further necessity to prove those breaches.
What further necessity was there than to refer to the witness affidavit that it would have been, which said, here's the order, there's been no compliance?
Well, for example, her evidence on that point, if necessary. I know she didn't give evidence, I accept that. But it just took out of the issue.
I understand that entirely. But in real practical terms, it could only have shortened the hearing if there would otherwise have been a live dispute about these facts. And the facts are, here are the orders, 2 of them, I think. There's been no compliance.
Yes.
It's not a lengthy inquiry.
It's not going to make that much difference, I have to accept that. I just say it's wrong to say no difference. I say it would have made some difference. To that extent, a discount is appropriate.
What time is saved by admitting that which cannot be denied?
Yeah. Yes.
All right. So, having regard to the time, is there anything else that you want to submit to us?
May I just check, please? Only this. It's not a point that, in fact, is an issue, because there was no harm or prejudice identified by the SRA to clients in this case, and the judge accepted that. But in my submission,
accepted it up to a point. He said there wasn't any positive evidence.
yes, that's right.
I've looked at your paragraph 29. Mr. Arnold pointed out the SRA is unable to assess the prejudice, which he accepts that submission up to a point.
Yeah.
If you haven't had the files, you don't know what you haven't had.
No, I follow that.
So you don't know whether there's been a failure to comply with time limits and so on.
Yeah, what the judge did was to say there was no evidence of failure to comply with time limits, for example, and other procedural aspects of the cases of the clients of the firm, for example, which will be tangible evidence of prejudice to those clients. I take the point that until you see it, you can't 100% say. But all I would say is, on the evidence before the court, there was no prejudice, no demonstrated prejudice to any client of this firm.
Can I just ask you what, in your submission, is the policy reason why, when there's been an intervention, the files of clients should be handed over to somebody who they have not chosen as their solicitor, a point made
Yes.
by the clients. What's that policy reason?
Well, the policy reason I accept is to review the conduct of the case.
Well, I'm not sure. It's partly that. It's partly also to ensure the client is not left without a solicitor, because once the firm has been intervened on, all the clients are left without a solicitor.
But my understanding of the position may be defective. My understanding of the position is that it's left effectively to the lay client to seek for alternative representation.
But I think that the intervention agents, Gordon's in this case, look at each file, contact each client and say, what do you want to do?
Yeah.
And our advice is to go and instruct somebody else.
Yes. I'm not suggesting otherwise. I think they give them some assistance.
Yes.
But it is not the position that some people may imagine it to be, where the SRA, as it were, through their intervention agent, take over the conduct of the particular case.
But can we not, if that's the policy, that the client should have a solicitor at a point at which their chosen solicitor can no longer practice?
Yes.
Even if the extent of that solicitor's assistance is simply to say, I've looked at your file, you should instruct somebody else, can we not assume that failure to comply and cooperate with an order to that effect is liable to give rise to the risk of prejudice to a client,
Yes, but what we do know in this
even if
case,
there's no tangible evidence?
No, I follow that. I follow the point. What there is evidence of here are clients. There weren't actually that many clients. Court will see from the paperwork. But there is evidence that a number of clients did in fact seek alternative representation and obtain alternative representation. And the court also has as I say, go back, this is why partly the affidavits all the emails are important, because it's perfectly clear that those clients wanted to remain with Ms. Khan, and there were third-party reasons why they did not in fact seek alternative representation at that stage.
One thing they because the one thing they can't do is continue to use her.
No.
Because her practice has been intervened on, and somebody needs to explain that to the clients, and that's one would have thought one of the roles of the intervention agents.
And the emails to that extent could be said to be evidence against your client, because the emails make it abundantly clear that those individuals do not understand the consequence of the intervention is that Ms. Khan can't act for them.
I follow that. I mean, in fact, her practicing certificate was suspended by definition.
Indeed.
Yes.
At the intervention.
Yes.
So it's a difficult position that she's in those circumstances. So I do take Milord's point. I do, with respect, see the point that
yes,
that in the absence of positive evidence of prejudice, that doesn't necessarily mean that there is no prejudice.
Your point is the judge accepted there was
yes.
no positive evidence.
No positive evidence.
Yes, thank you.
That's my point. Yes. And of course, I just say finally that prejudice to clients is, of course, in combination with culpability, the most important feature of aggravation or I suppose mitigation, in the sense that the absence of prejudice, whether that's mitigation or just not an aggravating feature, is a moot point, which I needn't take up the court's time with. But the fact of the matter is, it's an important consideration in sentencing. So for all these reasons, my submission is that the sentence here was manifestly excessive.
Very good. Thank you very much for those submissions. We will rise briefly to take stock. The link continue until we come back.
What time did it say? What time did it say? I think. Oh, they may say they're not here. May say they're not here. Is there something you wanted to mention? Yeah, can we do that? Back.
Got rise.
So, Mr. Allen, we needn't trouble you. Given the potential time pressure, I will announce straight away that despite Mr. MacDonald having said everything that can be said on behalf of the appellant, the appeal is going to be dismissed, and I will give our reasons very shortly. This is an appeal by Ms. Soophia Khan from an order of Mr. Justice Leech dated the 12th of January 22, finding Ms. Khan guilty of contempt of court and imposing a sentence of 6 months in prison. The appeal is only against the sentence imposed by the judge, not against the finding of contempt. The background is fully set out in the judge's comprehensive judgment, also dated the 12th of January 2022 EWHC 45 Chancery, to which reference should be made. For present purposes, a brief summary will suffice. Ms. Khan is a solicitor who was admitted on the 1st of November 2006. Prior to the 19th of August 2021, she was the sole principal and director of Sophia Khan and Co. Limited, a firm of solicitors. On the 19th of August 2021, the Solicitors Regulation Authority Limited, which exercises the regulatory functions and powers conferred on the Law Society under the Solicitors Act 1974, decided to intervene in Ms. Khan's practice. On the same date, the SRA wrote to Ms. Khan requiring her to provide all documents in her possession or control, or in the possession or control of herself or her firm relating to her practice to the SRA's approved intervention agent. In doing so, the SRA was exercising the power conferred under paragraph 9, subparagraph 1 of Schedule 1 to the 1974 Act. Ms. Khan did not comply with that requirement. Accordingly, an application was made to the court by the SRA, and on the 7th of September 2021, Mr. Justice Adam Johnson made an order, among other things, requiring delivery up by Ms. Khan of all the practice documents. Again, Ms. Khan did not comply with that order. There was an application by the SRA for further relief, and on the 21st of September 2021, Mr. Justice Miles made a second order, among other things, for delivery up of the practice documents. Again, Ms. Khan did not comply. On the 16th of September 2021, Ms. Khan applied to set aside the first of those orders, that is to say, the order made by Mr. Justice Adam Johnson. On the 1st of October 2021, the SRA applied to commit Ms. Khan to prison for her breach of the two orders made by Mr. Justice Adam Johnson and Mr. Justice Miles. Towards the end of the pendency of that application, on the 9th of December 2021, Ms. Khan's solicitors wrote to the SRA's solicitors, informing them that Ms. Khan accepted that there had been non-compliance with the orders of the 7th of September 2021 and 21st of September 2021, and informing them also that she did not intend to offer any evidence in her defence of the application for committal. On the 16th of December 2021, a letter was written by Dr. Khalid Chowdhury of the Al-Waqas Medical Centre in Leicester, which was made available to the parties in the court. The content of that letter was accurately summarised by the judge at paragraph 53 of, I beg your pardon, paragraph 36 of his judgment as follows. In his quote, in the letter he confirmed that Ms. Khan was a patient of the practice, that she was suffering from work-related stress and anxiety due to the ongoing litigation with the SRA, and that it was continuing to have a profound effect on her mental and psychological well-being and affecting her comprehension and understanding of that litigation. He also stated that she was unlikely to be in a mental state to be able to fully evaluate and comprehend the issues before the court in relation to the contempt applications. Finally, he stated that she was being referred to a private psychiatrist in view of her current mental health condition, end quote. The committal application was heard before the judge on the following day, the 17th of December 2021. At that hearing, counsel acting for Ms. Khan applied for the hearing to be adjourned in order that Ms. Khan should be able to obtain expert psychiatric evidence as to her condition. The judge refused that application, and there is no appeal against his refusal of the adjournment application. The judge reserved judgment at the end of the hearing. In the event, judgment was delivered slightly later than had been originally intended due to intervening events, and it was, as I've already indicated, eventually handed down on the 12th of January 2021. In the meantime, on the 31st of December 2021, Ms. Khan issued a further application, this time to set aside the second of the two orders to which I've referred, the order made by Mr. Justice Miles on the 21st of September 2021. On the 11th of January 2021, that is to say the day before he ultimately handed down his judgment on the committal application, the judge heard and dismissed both of Ms. Khan's set-aside applications. Again, there is no appeal against his dismissal of those applications. In his judgment on the committal application of the 12th of January 2021, the judge found that Ms. Khan was indeed guilty of contempt of court as alleged by the SRA. As I've already indicated, there is no appeal against the finding of contempt. Having reached that conclusion, he turned to the question of sanction. There was no dispute before him as to the applicable legal principles, which he summarised at paragraph 52 of his judgment in terms derived from the skeleton argument prepared by counsel then appearing for Ms. Khan. He also set out at paragraph 53 a list of criteria for the assessment of the seriousness of contempts, which derives ultimately from the judgment of Mr. Justice Lawrence Collins, as he then was, in the case of Crystal Muse Limited and Meshrick, 2006 EWHC 3087 Chancery at paragraph 13. Those criteria are worth setting out again. They are as follows. A, whether the claimant has been prejudiced by virtue of the contempt and whether the prejudice is capable of remedy. B, the extent to which the contemnor has acted under pressure. C, whether the breach of the order was deliberate or unintentional. D, the degree of culpability. E, whether the contemnor has been placed in breach of the order by reason of the conduct of others. F, whether the contemnor appreciates the seriousness of the deliberate breach. G, whether the contemnor has cooperated. And then H, a point added by Mr. Justice Popperwell in Asia Islamic Trade Finance Fund Limited and Drum Risk Management Limited 2015 EWHC 3748 COM, whether there has been any acceptance of responsibility, any apology, any remorse, or any reasonable excuse put forward. In his judgment, having set those criteria out and having reminded himself that this court has emphasised that a sentence of imprisonment should only be imposed if nothing less than a custodial sentence is justified. See McKendrick and Financial Conduct Authority 2019 EWCA 524. The judge went on to work his way systematically through each of the criteria that I have mentioned. His starting point before considering the individual criteria was that he, as he explained at paragraph 57, considered that the contempt of court was a serious one. Ms. Khan had committed breaches of 2 orders which were clear on their face. He found that Ms. Khan knew she was acting in breach of them and understood the consequences of the failure to comply with them. It was necessary for the SRA to obtain those orders to compel Ms. Khan to comply with her obligations to her regulator. Thus, her failure to comply with the orders involved not only an attack on the administration of justice, but also defiance of her regulator. The powers of the SRA to intervene in a solicitor's practice were intended to protect both members of the public and public confidence in the profession, and there was a strong public interest in ensuring that solicitors cooperated promptly with the SRA. Finally, Ms. Khan was a solicitor and therefore should be held to a higher standard than an unqualified defendant. Against that general background, he proceeded to consider the various criteria. In paragraph 56, he considered the question of prejudice to harm. He noted that the SRA was unable to point to any prejudice or harm which the clients of Ms. Khan's firm had suffered because of her failure to cooperate. or to comply with the orders. It had been pointed out by counsel for the SRA that the SRA was unable to assess the prejudice or harm which clients might have suffered until Ms. Khan had delivered up the practice documents. He accepted that submission up to a point, but he noted that there was no evidence of any complaints having been made to the SRA by clients as a result, for example, of time limits having been missed. He therefore accepted the submission of counsel for Ms. Khan that some discount should be made for the absence of harm or prejudice. At paragraph 56, he found that Ms. Khan had not acted under pressure from third parties to commit the breaches of either order, and therefore he could give her no discount for that reason. At 58, he reiterated that the breaches of the orders were deliberate, they had continued for some time, and on any view they were serious breaches. At 59, he concluded that for those reasons the degree of culpability was high. Even if Ms. Khan had arguable grounds for challenging either orders, she was required to comply with them until they were set aside. The nature and length of the breaches and the degree of culpability suggested that an immediate custodial sentence was justified in the absence of any other mitigating factors. At paragraph 60, he found that Ms. Khan was not placed in breach of either order by the conduct of third parties, and again, therefore, he could give her no discount for that reason either. Under paragraph 61, he noted that there had been no acceptance of the breaches prior to the letter of the 9th of December 2021. Moreover, until he had dismissed the application from adjournment on the 17th of December 2021, Ms. Khan had given no indication that she intended to comply with either order. Even then, she did not accept that she had committed the breaches deliberately or that she was in contempt of court. He therefore concluded that her failure to accept that she was in contempt or to recognise the seriousness of those breaches merited no discount. At paragraph 62, he noted that there had been no offer to cooperate prior to the refusal of the adjournment, and that although at the conclusion of the hearing on the 17th of December 2021, Ms. Khan had offered through her counsel to deliver up the relevant documents, she had not done so, but instead had issued the second set-aside application on the 31st of December 2021. He therefore gave her no discount for cooperation. In paragraph 63, he noted the admission that Ms. Khan had acted in breach of the orders, which admission had been repeated by her counsel both in his skeleton argument and orally at the hearing on the 17th of December 2021. He pointed out, however, that Ms. Khan had not admitted that she was in contempt, nor has she expressed any remorse or put forward any reasonable excuse for her conduct. He therefore said that he would make no discount for the limited admissions made on Ms. Khan's behalf because they had led to no saving in time or costs. Indeed, having made the admission that she was in breach of the second order, Ms. Khan had immediately applied to set it aside. At paragraphs 64 and 65, he turned to consider the question of personal mitigation. He accepted that Ms. Khan had no criminal record and no disciplinary findings against her. He also accepted that she had suffered a serious hand injury which had impeded her. Finally, he said that he gave full weight to Dr. Chowdhury's assessment of Ms. Khan's mental condition. He said that that could not excuse Ms. Khan's conduct, but it went some way to explain why she adopted such a wrong-headed attitude to the intervention and the subsequent court orders. He went on to take into account the effect of the litigation on Ms. Khan's personal and professional life. As he recognised, intervention is very intrusive and can effectively destroy a solicitor's practice. Ms. Khan had no current source of income and was living with family. He also took into account the fact that Ms. Khan had no experience of prison and that a period of imprisonment would be extremely hard for her given her psychological condition and the current pandemic. In all of those, taking all of those factors into account, he concluded at paragraph 66 that Ms. Khan's conduct amounted to serious, contumacious flouting of orders of the court, meriting an immediate custodial sentence of a significant length, and he concluded that the minimum sentence he could impose was 6 months. He divided that as into 2 parts. The first 3 months to be imposed by way of punishment for past breaches, and a further 3 months to secure compliance with the orders in question, which was capable of being remitted upon an application by Ms. Khan to purge her contempt. Turning then to the appeal, there is no dispute that the correct approach to an appeal of this nature is that stated in the leading authority, which is the decision of this court in the FCA McKendrick case, which I mentioned earlier. In that case, Lord Justice Hamlin, and as he then was, and Lord Justice Holdroyd, gave a joint judgment in which they said at paragraphs 37 and 38 as follows: in deciding what sentence to impose for a contempt of court, the judge has to weigh and assess a number of factors. This court is reluctant to interfere with decisions of that nature and will generally only do so if the judge, 1, made an error of principle, 2, took into account immaterial factors or failed to take into account material factors, or 3, reached a decision which was plainly wrong in that it was outside the range of decisions reasonably open to the judge. I will omit the citation of supporting authority. 38, it follows from that approach that there will be few cases in which a contender will be able successfully to challenge a sentence as being excessive. If, however, this court is satisfied that the sentence was wrong on one of the above grounds, it will reverse the decision below and either remit the case to the judge for further consideration of sanction or substitute its own decision. As they went on to state in paragraph 47, it is the sentence actually imposed by the court which must be outside the range reasonably open to the judge if an appeal is to succeed, rather than, for example, any starting point from which the judge may have been working. In Hussain and Vaswani, 2020 EWCA Civ 1216, it was submitted as recorded in my judgment at paragraph 50, that the sentence that had been imposed was outside the range of decisions reasonably open to the judge, and it was accepted that that test was essentially the same test as the manifestly excessive test applied by the Court of Appeal Criminal Division to criminal sentences. Counsel for Ms. Khan has accepted that that is indeed the correct test to be applied in the present case, given that, as in that case, it is not suggested that was any error of principle on the part of the judge, or that he took into account immaterial factors or failed to take into account material factors. In support of the submission that the sentence of 6 months is manifestly excessive, a number of points are advanced on behalf of Ms. Khan, which I will take in turn. The first point that is relied upon is the evidence of Dr. Chowdhury in the letter of the 16th of December 2021, to which I have already referred. The submission made on behalf of Ms. Khan is that although the judge stated that he would give what he described as full weight to that evidence, the reference being to paragraph 37 of his judgment, when determining the appropriate sanction, when it came to the assessment of sanction, it is said that the judge did not give proper weight to that evidence. Counsel argued that the evidence of Dr. Chowdhury was evidence that was directly relevant to the culpability of Ms. Khan for the breaches found by the judge, and indeed was relevant to no less than 5 of the 8 criteria considered by the judge and worked through by him in his judgment. I do not accept that the judge failed to give proper weight to the evidence of Dr. Chowdhury. The evidence of Dr. Chowdhury was undoubtedly evidence that the judge was right to take into account, but it was limited in its extent. As the judge's summary rightly indicates, the evidence is expressed in the present tense. It deposes to the view of the Ms. Khan's general practitioner that the litigation was having a profound effect on Ms. Khan's mental and psychological well-being, and was affecting her comprehension and understanding of recent issues in recent litigation matters brought against her. The date of this evidence is, as I've already indicated, the 16th of December 2021. That is to say, the very day before the hearing of the committal application. It is unsurprising that any respondent to a committal application would be feeling very stressed the day before a hearing of an application for them to be committed to prison. What Dr. Chowdhury does not do in his letter is to identify the date when the symptoms which he speaks first manifested themselves, nor does he express any opinion as to the effect of those symptoms, if manifested at an earlier date, to deal upon Ms. Khan's ability to comply with the orders of the court, or even to understand what the consequences of non-compliance would be. In those circumstances, it seems to me that the judge was plainly correct to say, as he did in paragraph 64, that Dr. Chowdhury's assessment of Ms. Khan's mental condition could not excuse Ms. Khan's conduct, although it went some way to explaining why she had adopted such a wrong-headed attitude to the intervention and the subsequent court orders. Indeed, in taking that view, it could be said that the judge had taken a generous view towards the evidence. The next point that is relied upon is that it is said that the judge gave undue credit, was wrong in not giving Ms. Khan credit for the admissions that were made in the letter of the 9th of December 2021. It is pointed out in that regard that it was held in FCA and Kendrick that it was an important point if a contemnor had admitted his or her wrongdoing and saved court time. The general practice in criminal cases is that if a prompt admission is made, a discount of 1/3 of the sentence that would otherwise be imposed will be applied, with a sliding scale of discount down to 10% if there is an admission at trial. Accordingly, it is submitted on behalf of Ms. Khan that the judge was wrong in the present case to give Ms. Khan no credit whatsoever for the admissions contained in the letter of the 9th of December 2021. As this court held in Lakatoma Shipping Code Limited and Sue 2021 EWCA Civ 1355, however, there is no absolute rule that in cases where an admission of contempt is made, some credit has to be given to the contemnor. In that case, this court upheld a sanction of 2 years imprisonment being the maximum that is possible under statute in circumstances where there had been a belated admission by the contemnor. Turning to the present case, it seems to me that the judge was entirely justified in giving Ms. Khan no credit for the admissions made. In the first place, as the judge pointed out, the admissions made were simply of non-compliance with the orders of the court. There was no admission of contempt of court. The judge's assessment was that as a result, there had been no saving in time or costs. That is an assessment with which this court cannot possibly interfere, seeing as how the judge had the benefit of knowing exactly how proceedings had proceeded before him. Moreover, it is an assessment which, on its face, makes good sense. In effect, all that Ms. Khan did was to admit that which could not be denied. Given that she did not admit contempt, it was still necessary for the court to receive submissions as to whether, in particular, the mental element of contempt of court required for a finding of contempt of court was present, and for the court to make a decision on liability. Furthermore, although he did not refer to it in paragraph 63 of his judgment, the judge would have been entitled to take into account the fact that the purpose of committal applications in a case of this nature is not purely to sanction the contempt or alleged contempt or for past breaches of the court's orders, but also to attempt to secure future compliance. That is, as I have explained, the reason why, in this case, the judge split the sentence he ultimately imposed into two parts. The first part being directed to punishment for the past, and the second part directed to compliance for the future. As at the date of the hearing, and indeed as at the date of the judgment, there had been no compliance by Ms. Khan with either order of the court. In those circumstances, it seems to me she could not realistically expect any discount on the sentence that would otherwise be imposed. It would be quite different if she had belatedly made steps towards compliance. Even now, as of the date of the hearing before this court, there is no evidence that Ms. Khan has either complied with either order or indeed made any attempt to do so. The next point that is taken on behalf of Ms. Khan is that the judge failed to give sufficient weight to the absence of any specific evidence of prejudice or harm which clients of Ms. Khan's firm had suffered as a result of her non-compliance with the orders. So far as that is concerned, however, the judge stated that he accepted the submission that some discount should be made for the absence of harm or prejudice. The extent of the discount to be applied was a matter for the evaluation of the judge. This court is in no position to interfere with the judge's assessment. Indeed, it can again be said, that it might again be said that the judge's assessment was a generous one, as my Lord Justice Nugee pointed out during the course of argument. Part of the point behind the powers conferred on the SRA by paragraph 9 of Schedule 1 of the 1974 Act is to enable the SRA's intervention agent, once the firm's files have been secured, to contact the clients of the firm to ensure, apart from anything else, that they are not without legal representation and advice. Ex hypothesi, in circumstances where there has been an intervention, the former solicitor will no longer be able to act for the clients. Accordingly, they will need to instruct fresh solicitors. They may choose to instruct the intervention agent, they may choose to instruct a different firm, but they will not be able to continue to instruct the solicitor in question, and they need to know that as soon as possible. Therefore, it is inherently likely that if the solicitor refuses to deliver up the firm's files, that clients will be prejudiced. The next point that is made is that the judge found that Ms. Khan had not acted under pressure from third parties to commit breaches of either order. It is accepted on her behalf that that was correct so far as the evidence that was available before the judge was concerned. However, an application is made to this court to adduce fresh evidence showing, it is said, that Ms. Khan was in fact acting under pressure from her clients. In that regard, reliance is placed upon an affidavit of her solicitor, Mr. Livingston, of the 26th of January 2022, which exhibits two unsolicited emails received by his firm, the first of which was sent by a client on the 15th of January 2022 at 14:02, and the second of which was sent by a different individual on the same date at 14:32. The two emails are in very similar terms to the extent that they share certain spelling mistakes. Both emails say that the clients are making a complaint against the SRA for having demanded their files from Ms. Khan without the individual's consent. Both emails state that they have instructed Ms. Khan not to share their files with the SRA and express in strong terms their concern at the prospect of the SRA having access to their files. There is no evidence before the court to explain the genesis of these two emails. It is to be inferred that they have come into existence as a consequence of the judge's judgment and order, given that they postdate them and given that they have been sent to the solicitors acting for Ms. Khan in December and January, December 2021 and January 2022. Other than that, the precise genesis of the communications is a mystery. It is obvious, however, that the two individuals in question have been in contact with each other, given the proximity of their communications in point of time and given the similarity in terms of content. There is no evidence from Ms. Khan herself to say that she was placed under pressure either by these two clients or indeed any other clients. Nor even is there any evidence from Ms. Khan to corroborate the points made by the individuals in question or to provide any kind of context. Against that background, the first question is whether the new evidence should be admitted. it is accepted that the traditional Ladd and Marshall criteria form the basic framework for the assessment of an application to admit new evidence in this court. It is submitted that the Ladd and Marshall criteria are satisfied because the evidence postdates not only the hearing but also the judgment, and it is said that it is credible evidence which would have a material impact on the outcome. I do not accept that the Ladd and Marshall criteria are satisfied in the present case. This evidence is evidence of a nature which could plainly have been put before the judge if the point that Ms. Khan was being put under pressure by her clients was one that was to be taken. If that was the case, she herself could have given first-hand evidence of that fact, but yet she did not do so. Equally, she could have produced supporting evidence from clients to support that proposition. It is of note, as counsel for the SRA points out in his skeleton argument on this appeal, in that regard, that Ms. Khan did produce witness statements from clients in support of her set-aside applications. Accordingly, this is evidence which could have been obtained with reasonable diligence prior to the hearing below. Moreover, given the absence of evidence even now from Ms. Khan, this is evidence that cannot be given weight. Even taking what the individuals in question say entirely at face value, they have clearly not understood that the consequence of the SRA's intervention into Ms. Khan's practice is that Ms. Khan is unable to continue to act for her, and that they need to accept or need to obtain alternative representation from different solicitors. Nor has it apparently been explained to them that they need have no concerns as to the privacy and confidentiality of the documents in question, because the SRA and its intervention agent are obliged to respect those important considerations. Indeed, it could be said that the evidence contained in these emails is in fact missing evidence of the kind that was missing before the judge, showing how clients have been prejudiced by Ms. Khan's failure to comply with the orders of the court. Even if the evidence were to be admitted, it seems to me that the judge's finding would remain unimpeachable for the reasons that I have given. The final point that is advanced on behalf of Ms. Khan, at least in writing, although not repeated in Ms. Counsel's oral submissions, is that the judge had failed to give proper weight to the aspects of personal mitigation relied upon by Ms. Khan before him. That is a point which counsel was correct not to pursue orally. It is a hopeless point, given that the judge expressly considered the personal mitigating factors and stated that he was taking them into account. As this court made clear, both in FCA and Kendrick and Hussain and Vashwani, the key question is that of the ultimate sentence imposed by the judge below and whether it can be said to be manifestly excessive. During the course of argument, a point that was raised in that regard by counsel Ms. Khan is that the fact that the judge had not, in the present case, proceeded by stating a starting point for his sentence and then applying an articulated discount to that starting point. That is an approach which has sometimes been adopted in the case of civil contempts, as can be seen for example, from the Hussain and Vashwani case, where the judge stated that he was taking as his starting point a sentence of 18 months. He applied and then applied various discounts to arrive at his final sentence of 12 months. As I've indicated, in the present case, the judge did not adopt that approach. Counsel for Ms. Khan did not suggest that there was any error of principle in not adopting that approach. He suggested, however, that it would have been helpful if he had adopted that approach. Furthermore, he suggested that this was something that it would be beneficial if judges were to do in future. I do not accept that there can be any uniform approach when it comes to civil committal applications. Unlike criminal sentencing, sentencing in cases of civil contempt of court is not subject to any statutory provisions save as to the limit on the sentence that can be applied and as to the degree of remission that is also to be applied. There are no guidelines from the Sentencing Council. Moreover, the case law shows that the sentences to be imposed are highly fact-specific. Yet further, as I've already discussed, a key factor in this jurisdiction is that of attempting to secure compliance, even if belatedly, with the court's orders. That is not a feature of criminal sentencing in most cases. While there will be cases in which it can be useful for the court to take a starting point and then apply a discount, I do not think that it can be said that that will always be helpful. It is particularly in a case of the present kind where there has been no real admission and no evidence of any evidence either of compliance or of any intent to comply in future, that an approach of that kind is least likely to be helpful. In short, not only do I see no error in the judge's approach, but also I am not convinced that it would have been a helpful exercise for him to have attempted to articulate a starting point and a discount for the factors that he did take into account. Standing back, at the end of the day, the question for this court is whether the sentence of 6 months which the judge imposed can be said to be manifestly excessive. In my judgment, it is plain that the sentence was not manifestly excessive. For those reasons, I would dismiss this appeal.
I entirely agree with the judgment that has just been delivered by my lord. Like him, at the end of the day, if one stands back and asks whether this sentence is manifestly excessive, I have not been persuaded, despite Mr. MacDonald's eloquence, that there was here a case in which the sentence could be characterised in that way.
My lord, there's just a question of costs. I was seeking order for Solicitors Regulation Authority's costs of the appeal. We have filed a cost schedule. I don't know if it's made its way to your lordship. So I
Unhappily not, no.
Well,
Let's deal with the principle first, and then we'll come on to the question of quantum in a moment. Can you resist an order for costs?
No, may I just say though that we are legally aided.
Yes.
Both of us.
So you'll require a legally aided assessment.
Yes, but because of the statutory provisions for civil contempt proceedings, although her costs are catered for of her representation, she gets no protection from the costs of the winning party. That was resolved by the judge on the last occasion, making an order for costs not to be enforced without leave of the court.
Right.
So
you're asking for the same order again?
I do, please, yes.
I don't oppose that rule.
Very good. So we will order Ms. Khan to pay the costs of the appeal, the SRA's costs of the appeal to be precise, but that order not to be enforced without the leave of the court.
We should say
Yes, and for the avoidance of doubt, when I say without the leave of the court, that will be the leave of the first instance court, because it's obviously undesirable that in the event of any question of enforcement arising, there should need to be two applications.
Yes.
Well, thank you. I do submit, however, that the cost claim, which, my lord, I don't think it's seen.
Well,
is an
I
excessive
haven't seen
one.
the schedule. Let's have a look.
Fine.
What is the grand total?
It's £15,177 total.
Well, can I just cut to my point, which is that I would respectfully submit that there should be a detailed assessment of the costs of this hearing.
If there were a detailed assessment, we should make an order for interim payment, unless there's a good reason not to. Do you have any submissions as to what level of interim payment?
Not in the light of the proposed order in relation to non-enforcement without leave.
And why do you say that this is excessive?
Well, if one looks at the final page, for example, fee for the hearing, for example, I'm sorry to say it, but counsel's fee for effectively repeating the submissions that have been made on an earlier occasion, simply redrawing a document that has already been in existence is, in our submission, excessive. For example.
All right. Well, we'll rise briefly to consider this. I mean, I take it, Mr. Allen, you would simply say that these sums are justified.
I would, my lord, and I would seek a summary assessment given that it's an appeal that's taken just half a day. The cost of a detailed assessment can be out of proportion with the sums claimed. In terms of the work done, just an attempt to justify my fee, it wasn't simply a case of regurgitating what was done below. It involved looking at what was pursued by way of appeal and producing a new document which responded to those grounds.
Okay, thank you.
Louder, please.
Yes. Yes.
So she has to.
Yes. Sorry.
Has she asked that one to hand over the file?
Well, she still remains under hold.
Huh?
I think we should discuss it outside.
All right.
Right, well, we don't think that a detailed assessment is justified, so we will summarily assess the SRA's costs in the sum of £12,000 plus VAT if it's certified that VAT is not recoverable by the SRA, because as counsel may be aware, you can't claim VAT on a bill of costs if you can recover it, but you can if it's not recoverable. Experience shows that counsel don't always know the answer to that question when asked. If that can be certified one way or the other, then the VAT will be added or not, as the case may be.
I will ask people who know better than me.
Yes, very wise. Very good. Anything else? Thank you both.